All right, so we are awaiting sort of the beginning of day 14 of the Derek Chauvin trial, but you can see that attorneys are speaking now. The trial has not begun, but there has been some discussion and conversations happening prior to the trial. Vlad, we heard earlier as we dipped in that that it looks like Derek Chauvin will not be taking the stand in his own defense. There was a lot of talk about whether or not that was the expectation. The expectation is that the defense will wrap up their arguments today, and so we thought if it's going to happen, today's going to be the day. And now we've learned that in fact Derek Chauvin will not be taking the stand. I'm not sure. Do we have the video and audio of him saying that and explaining why? Okay, let's roll that.
Mr. Chauvin, you and I have had several discussions throughout the course of my representation of you relevant to your right to testify or to choose to remain silent. Correct?
That's correct.
And during the course of our representation, it's fair to say that you and I have had this conversation multiple times, correct?
Correct.
You understand that you have a Fifth Amendment privilege to remain silent. Do you understand that?
Yes.
You understand that if you choose to exercise that right to remain silent, neither the state nor the court can comment on your silence as a sign or an indication of your guilt. Meaning they can't say, he didn't get up and defend himself, so equate your silence with guilt. Do you understand that?
Yes.
All right. Now, you also understand that you can waive that right and testify. Do you understand that?
Yes, I do.
You understand that if you chose not to testify, or if you did in fact testify, you would be subject to cross-examination by the state of Minnesota.
Yes.
You understand that if you were cross-examined by the state, we could not attempt to limit the scope of your testimony. The state would be given broad latitude to ask you questions. Do you understand that?
Yes.
We've had this conversation repeatedly, correct?
Correct.
I have repeatedly advised you that this is your decision and your decision alone, right?
Correct.
I have advised you, and we have gone back and forth on the matter, would be kind of an understatement, right?
Yes, it is.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
Right. Mr. Chauvin, I'm going to address you directly because the decision whether or not to testify, take this off, is entirely yours. In other words, it's a personal right. Mr. Nelson makes a lot of the decisions in trial, but one he cannot make for you is whether or not you testify. And he can give you advice, and you can take that advice or reject that advice. But the decision ultimately has to be yours and not his. Is this your decision not to testify?
It is, Your Honor.
All right. Do you have any questions about your right to remain silent or to testify on your own behalf?
Not at this time, I don't.
All right. Has anyone promised anything or threatened you in any way to keep you from testifying?
No promises or threats, Your Honor.
Do you feel that your decision not to testify is a voluntary one on your behalf?
Yes, it is.
Now, in addition to that, I'm convinced then that this is your personal decision and that you are aware of your rights. But there is a jury instruction that may be read to the jury. This, again, is the one that you get to weigh in on. It's not for your lawyer to make the decision. Again, he can give you advice, and I don't want to know what the advice is, but you can accept the advice or reject the advice as to whether or not to give this instruction. If you would like, I can read this instruction to the jury. It's titled, Defendant's Right Not to Testify. The state must convince you by evidence beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant has no obligation to prove innocence. The defendant has the right not to testify. This right is guaranteed by the federal and state constitutions. You should not draw any inference from the fact that the defendant has not testified in this case. Do you understand that instruction?
Yes, Your Honor.
Would you like that read to the jury?
Yes, Your Honor.
Have you had enough time to talk to Mr. Nelson about whether that's a good idea or not?
I have, Your Honor.
All right. And so I will read that to the jury on your request.
Thank you.
All right, so there you have it. We want to bring in Keir Dougall to give us a little bit of analysis. Keir, we talked about this earlier, whether or not you would have advised Derek Chauvin, if he was your client, to take the stand. You said no. I've heard others, at least earlier on in the testimony, argue that maybe he might have to because they didn't really feel like his defense had been particularly strong. But I suppose this does not come as a surprise to you.
No, this is what I expected, and that discussion between Mr. Chauvin and his lawyers is important. As we talked about earlier, this is not the lawyer's decision, it's Mr. Chauvin's decision. So the judge would have put that discussion on the record out of the presence of the jury. So to make it absolutely clear that Mr. Chauvin had made that choice and made it with the advice of his counsel. This does not surprise me, as we discussed earlier.
Doesn't surprise you, Keir, but is it, I guess the question I would have is it a missed opportunity? I understand that, of course, the prosecution would go on the attack and try to upend his testimony. On the other hand, is it an opportunity, a missed opportunity, to perhaps give the jurors a sense of where his mind was at the time and what he was thinking, as opposed to just having counsel repeatedly say, well, what about the crowd? Don't they present the threat? Or isn't this how you're supposed to restrain somebody? I just sort of want to know. I would think that the jury would want to know what he was thinking at that moment, and that could provide perhaps that one, that one bit of testimony that one juror needs to say, I'm not ready to convict.
Right. So if what we were watching was not in front of a jury and the stakes were not whether or not Mr. Chauvin would be convicted, Vlad, you're absolutely right. It would be a missed opportunity, and you would expect any ordinary person would want to defend themselves, would want to explain what they did. But we're in a very special setting, obviously, in a criminal trial in front of a jury where the prosecutor carries the entire burden of proof beyond a reasonable doubt. And so it is not Mr. Chauvin's obligation under our system of criminal justice, criminal law. It is not his obligation to explain himself. And in fact, the judge will instruct the jury later that they can draw no conclusion from his refusal to take the opportunity, Vlad, that you would, and frankly, all of us in our normal course, we would hope that someone would do and would explain perhaps what he was thinking, that he was sorry about it. All of those things in a normal conversation don't apply in this extremely fraught, special circumstance.
So, it looks like the defense is going to wrap up today. I'm curious as to what you believe they have left to do. We heard about a police officer that interacted with George Floyd in 2019. We saw video of that interaction. We heard from a medical professional talking about the various other factors that could have contributed to his death. What's left to say on the defense's part? Because I get where Vlad is coming from, that Derek Chauvin would be the only person to express the fear, terror, whatever it was he was feeling at the time, and he'd be the only one who can express that in a way that I think would have meaning to the jury. So where do they go from here in terms of the defense?
Right. So the next steps are if there are any other defense witnesses to call, finish that up. It sounds like there may not be if they're already discussing whether or not Mr. Chauvin will testify. There might be one final cleanup witness, maybe some other witness the defense will call. There will be questions about whether the prosecutors are going to put on any rebuttal testimony. We talked earlier about how this is not generally an opportunity for the prosecutors to retry the case, but to address new points that have come up in the defense case. What I heard a little bit of what was going on in the courtroom, and it sounds like they're arguing about that right now, whether or not what the scope of that any rebuttal case might be. After that, there are closing arguments by the attorneys, and the judge will give the specific legal definitions and criteria that the jury will use during deliberation. They will have specific instructions, definitions of what causation under Minnesota law is, what the different elements of the different charges are. And then the jury will go deliberate, and that could take a while. It could happen quickly, and we'll get one of three verdicts. We'll get a conviction, we'll get an acquittal, we'll get a hung jury.
So, all right. So I think Anne-Marie's question is sort of the one that I had burning in my mind, which is what's left for the defense to present to the jurors to make the case? What will be left in Mr. Nelson's defense of Derek Chauvin that will allow that, because we keep saying it, right? All you need is one person to say, you know, I'm not, you know, I think that that Derek Chauvin acted in a manner that his defense counsel has presented. And if he's able to do that, then what would be left for the prosecution to drive home the message that he did not?
Right. So the key battlegrounds have been causation, justification, and issues around the proper use of force. And so we've seen conflicting expert testimony, experts that have been qualified by the judge to come in and give a testimony to the jurors that they can take as expert testimony. And so you have, on the one side, the prosecution medical forensic evidence saying that it was a homicide. On the other side, we heard Dr. Fowler saying the cause is indeterminate. On the one side, we have the prosecution witness saying that the force was unnecessary, unreasonable, and it violated department policy. And we had a witness from the prosecution, police procedures witness, testify in contradiction to that. These jurors are going to have to balance, have to decide which set of witnesses are credible. And in order to find for the prosecution, not only would they have to find that the prosecution experts are credible, but that they're right beyond a reasonable doubt. And all 12 of them would have to reach that conclusion, side with the prosecution's experts. If one of the jurors sides with the defense experts, you'll end up with that there isn't proof beyond a reasonable doubt, that the prosecution is correct on these theories. You'll have a hung jury. If all 12 of them side with the defense expert witnesses, you'll have an acquittal. And what we're going to see is any last evidence that the defense wants to put in, any rebuttal evidence that prosecutors want to address new issues with, and then arguments by counsel, by the prosecutors. They'll go first. The defense lawyers will then reply, and the prosecutors will get the final word in a short rebuttal argument before the jury gets the instructions and goes to deliberate.
Keir, let me ask another question on that. What is the difference between, legally speaking, between force and violence? Because a lot of the questioning around policing in this country and the harm that sometimes befalls people focuses on what's called excessive force, which I guess presumes the legal legitimacy of using force in the first place in a specific situation when there is the threat of violence, because violence is the use of illegitimate force. Am I right?
Right. So a lot of these issues about procedure and justification are complicated by the fact that law enforcement is when they're executing trying to arrest somebody, when they're executing an arrest warrant, when they're trying to serve process, they are often met with, at times they're met with resistance. Now my advice to anybody out there is to comply with a law enforcement officer and deal with it later. If the officers are mistaken or if they're doing something wrong, you'll get your day in your court. You'll have an opportunity to point that out, but don't escalate a conflict. The officers have a lawful duty to take people into custody, and they have a right to defend themselves, and they have a right to use force as long as it's reasonable and proportionate under the circumstances to effect an arrest, take somebody into custody. So this question about excessive force is what we've been hearing about. And, whether it's violence or whether it's excessive, may be something that's what we have juries to decide. And Vlad, of course, we have to acknowledge a long history of improper use of force with respect to certain populations in the United States. That's something that officers are trained about and continue to need to be trained about, and adjustments in policy undoubtedly continue to need to be made so that we can de-escalate these situations and avoid tragedy as we're watching in the Floyd and in other cases.
Keir, not too long ago, maybe, I don't know if it was earlier this week or last week, I was speaking to one of our other legal analysts, Vinu Varghese. He's been a prosecutor and a defense attorney, and he pointed out something that I was kind of unaware of. He felt, as he was watching this trial, that it was very clear that the prosecution side had way more resources than the defense side, based on the number of experts and other people who were well-versed in law enforcement and training that they were able to bring up, several people to basically reinforce the same points over and over again. This isn't part of the training. This isn't how it's supposed to go. And he actually thought that, based on that and the performance of the defense, that there might actually be sort of grounds for appeal, that there was an imbalance in the resources that both sides had. Is that a legitimate grounds for appeal?
Well, I guess the question there is going to be whether or not there was an excessive number of repetitive, redundant witnesses that would have prejudiced the jury. Appeals like that can be taken, but I don't believe they're generally going to be have a high degree of success. So, that is an argument that you can make on appeal. I don't know that a set of appeal judges would be particularly moved by that. I think the larger point is that Mr. Chauvin has called, his own witnesses. Although there may be an imbalance in the numbers, he has called his own experts to put on a defense. So he's had his opportunity to put his theory in front of the jury.
Keir, going back to your point about compliance, it's interesting. Emery and I were just talking about it earlier this morning, and I actually had a conversation with a friend who's a retired police officer who also suggested what you did, right? Which is that many of these incidents would not have occurred if suspects just complied with police officer's request. But then the question, of course, becomes and you heard that testimony, Barry Broad, who was a use of force expert, at one point, Emery, correct me if I'm wrong, he said something like police officers are allowed to go beyond a certain level.
Yes, they don't have to fight fair.
Right. They don't have to fight fair. So is it then thus that because the bar to convict a police officer of excessive force is so high that all of these issues would not exist if a suspect just complied? I think a lot of people find that the notion that every time you interact with a police officer, even if they are trampling on your rights, you should just comply unless you find yourself in a situation like Derek Chauvin, like George Floyd or Daunte Wright.
Yeah, these are really tough questions, Anne-Marie and Vlad. These are the issues that, as a society, I think we're going to debate and probably continue to debate for a long time. Now, I was struck by the way Mr. Broad said that the police don't have to fight fair. I think that's a really unfortunate phrasing of an idea that I think that's a charged way to describe an idea that's simpler. Police officers maybe have a little more leeway in responding with more force when they're facing someone who is resisting arrest and when they are effectively defending themselves and carrying out their lawful duties. They maybe have more leeway than an ordinary citizen would have simply to defend themselves, because if they're in an altercation, because the officer's got to do more than just defend himself. He's supposed to, take custody of this particular defendant or suspect. So the officers certainly do have some more leeway, but the way Mr. Broad described it as they don't have to fight fair, I think that does a big disservice to the conversation that we all need to have. Now look, my advice to anybody facing a law enforcement officer is absolutely to comply. Absolutely, you're caught in a moment. You feel like you need to try to get out. How do I avoid this? But if there's a mistake, if there's a problem, you will have your opportunity, to bring that problem up. It'll be inconvenient because if you're taken into custody and you have to appear in court, it's a terrible inconvenience. It's embarrassing, but it's the process. It's what we have to live with here. Of course, people have confronted with a law enforcement officer. Of course, everybody has a right to defend themselves if they believe that, that they have to. But generally, my advice to anybody would be to comply and deal with the problems down the road when you can get in front of a judge.
Keir, thank you very much. You're also reminding me that the other thing that use of force officer said was that George Floyd should have been resting comfortably when he was pinned against the concrete with his hands handcuffed behind his back. Keir, we're going to let you go for now. Court is taking a bit of a recess. I think they're going to reconvene a little bit after 11 o'clock. So we're going to give you a break from us and pull away. Thank you so much.
Thank you.